Good morning, everybody. My name is Pranav, a legal intern at LEXIS and Company for the month of June. And I said in yesterday's session, today I will be talking about the contract of agency, the duties and rights of an agent. What is a contract of agency? Under Section 182, an agent has been defined as a person employed to do any act or to represent the principal in the dealings with the third party. Agent is authorized to create a contractual relationship between the party and the third party. The principles underlying the contract of agency are: what a person can do by himself can get it done by some other, provided that the work is not of a natural personal nature, and secondly, the act done by the agent is considered as the act done by the principal itself. Now let's look at the distinction between a servant and an agent. The first basis of distinction is on the basis of scope of authority. Servant is not authorized to create a contractual relationship between his master and third parties, whereas an agent is authorized to create a contract between the principal and the third parties. Second basis is the remuneration. Remuneration for a servant will be given in the form of wages or salary, but a remuneration for an agent will be given in the form of a commission. Third basis of distinction is on the basis of control. Servant is subject to direct control or supervision by his master. An agent cannot be fully controlled by his principal, he enjoys some discretionary power. And the last basis of distinction is on the basis of liability. The master will be held liable for the wrongful acts committed by the servant during the course of his employment. But a principal's liability is limited because he will be liable only for those wrongful acts committed by the agent while acting within the scope of his authority. Now let's look at the duties and rights of an agent. What are the duties of an agent? There are eight duties of an agent. Firstly, an agent's duty in conducting the principal's business. As per Section 211, an agent shall act within the scope of authority that his principal confers upon him. Also, he shall strictly follow the directions of his principal. However, in the absence of any express instructions from his principal, he shall follow the custom prevailing at the place where he carries out his business in a similar type of business. When the agent acts otherwise, if any loss be sustained, he must make it good to his principal, and if any profit accrues, he must account for it. Second duty is the skill and diligence required from an agent. An agent is bound to conduct the business of the agency with as much skill as is generally possessed by persons engaged in similar business, unless the principal has notice of his wants or skills. The agent is always bound to act with reasonable diligence and to use skill as he possesses, and to make compensation to his principal in respect of direct consequences of his own neglect, want of skill or misconduct, but not in respect of loss or damages which are directly or indirectly or even remotely caused by such neglect, want of skill or misconduct. Third duty is duty to render proper accounts. According to Section 213 of the Indian Contract Act, an agent is bound to render proper accounts to his principal on demand. Fourth duty is the duty to communicate with the principal. It is a duty of an agent in cases of difficulty to use all reasonable diligence in communicating with his principal and in seeking to obtain his instructions. Fifth duty, not to deal on his own account. Section 215 of the Act deals with the right of principal when an agent deals on his own account in business of agency without the principal's consent. Next duty is not to make secret profits. There is a fiduciary relationship here and there is trust because of the same between the principal and agent, and hence the agent has a duty to not make any secret profits, and if the principal comes to know about it, he can claim all those profits back from the agent. Seventh duty is the duty to pay sum received for principal. According to Section 218 of the Act, an agent is bound to pay his principal on all sums received on account. The agent's money from the pocket that he spent can be deducted, and the rest has to be surrendered by the agent. And the last duty is duty not to delegate authority. There are certain exceptions to the principle of delegates non-protest delegate. The above principle means that a delegate cannot further delegate. Therefore, an agent cannot appoint a sub-agent. However, there are certain exceptions to this principle. Firstly, when the principal allows delegation. Secondly, where there is custom or usage of trade or trade to delegate. Thirdly, when delegation is necessary for proper and efficient performance. Fourthly, when it becomes essential due to some emergency. Fifthly, when the principal knows that the asset's intention is to delegate. And the last exception is when the work is ministerial. Moving on to the rights of an agent. The first right is right to receive remuneration. According to Section 219 of the Indian Contract Act, an agent is entitled to a reasonable remuneration for rendering the services to the principal that are not voluntary or gratuitous. Remuneration amount will be decided by the principal and agency when the contract of agency is made. An agent becomes eligible to receive remuneration as soon as he completes the work that he has understood. The second right is right to lien. In absence of any contract to the contrary, an agent is entitled to retain goods, papers, and other property of the principal received by him until the due amount of himself for commission disbursements and services in respect of the same has been paid or accounted to him. Some agents who have the possession of goods, services, and properties of the principal also have a lien on goods, securities, and properties regarding their remuneration. Right to indemnity. Indemnity means promise to make good the loss or to compensate or protect the person. According to Section 222 of the Act, the agent has the right to be indemnified or compensated for all the losses that he suffered during the course of employment only while acting lawfully. Fourth right is the right to compensation. According to Section 225, an agent is entitled to claim compensation for the injury suffered as a consequence or want of skill of principal. The agent has the right to be compensated for the injury due to the negligence of the principal. Right of retainer. According to Section 217, an agent has the right to retain his principal's money until his claim, if any, in respect of his remuneration or advances made or expenses incurred in conducting the business of agency are paid. The right can be exercised on any sums received on account of the principal in the business of agency. He can retain only such money as is in his possession. The next right is right of stoppage of goods or principal. The agent has the right to stop the supply of goods if the principal has become insolvent. And the last right is right to be indemnified against the act done in faith. According to Section 223, an agent has the right to be compensated against all the consequences of his act which he has done in good faith but which resulted in the violation or injury to the third party. With this, I come to the end for today's topic, and in tomorrow's session, I will be talking about the termination of an agency. Until then, goodbye and have a good day. Thank you.